Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone, I hope you're all well. So this month we're going to take a look at some proposed changes to employment law and also a case about expelling a member from a limited liability partnership. But first up, I've got another case in which the High Court set out some useful guidance on how to assess whether there's been a breach of a material adverse change provision in a share sale agreement. So we tend to refer to these material adverse change clauses as MAC clauses or MAC provisions. And they're designed to protect a buyer from a significant change in the commercial position of a transaction. So they can take lots of different forms. So you might get a clause that gives the buyer the ability to just walk away from a deal if there's a MAC, a material adverse change in the target between signing and closing. Or you might get something like a warranty, which gives the buyer a right to compensation if there's a MAC between, say, the target's financial position at a particular date, that's often the date of its last audited accounts, and then its actual position on signing. So to bring a successful claim for breach of a MAC provision, the buyer needs to be able to show not only that there has been a change in the relevant metric, whatever that is, but also that that change has been material. Now, the question of what is material sometimes will be set out expressly in the actual agreement, but often it isn't defined in the agreement. And that means that if there is a subsequent dispute, then it's going to be the court that has to determine what is material in the context of the relevant transaction. And that was the approach that the court had to take in this recent case, which dates back to events in October 2018, when a buyer agreed to acquire the shares in an IT consultancy company. So in this case, the share purchase agreement contained a warranty from the sellers to the buyer that since the 31st of December 2017, which was the date of the target's last accounts, there had been no material adverse change in the turnover, financial position, or prospects of the company. So that's our MAC warranty here. So the parties agreed that if you were assessing the value of the company, then the key factor was its ability to generate future revenues. And so the key metric was the company's future gross profit. The sellers had provided various documents in relation to the company's existing sales and pipeline and forecasts. And in particular, the sellers handed over information about 4 key contracts, and that was included in the pipeline. And the pipeline showed that all of those 4 contracts would begin generating revenue soon after the acquisition completed. So that completion took place on the 8th of October, but not long after that, it became pretty clear that the company's position was, in fact, much worse than that had been shown in the pipeline, and in particular, in relation to the progress of those 4 contracts, was nowhere near what had been projected in the pipeline. So the company made a small profit, just over £1,000 in November 2018, but then it made losses of over £95,000 in each of December 2018 and January 2019. So the buyer brought a claim against the sellers for breach of the MAC warranty on the basis that the buyer said, well, hang on a minute, there's been a material adverse change in the company's prospects since the 31st of December 2017. So it came before the court, and the court agreed with the buyer. but it's quite useful because the court's decision sets out how to assess whether there's been a breach of the MAC warranty. And the judge said, well, there's a three-stage test here. So firstly, you have to find your baseline figure. So that's the expected or forecast level of the relevant factor at the time of signing. Then you've got to find the actual figure, so the actual amount of that relevant factor at the relevant time. And then, having determined your baseline and your actual figures, you had to look at the difference between those two and decide whether that was so great that it amounted to a material change. So, when you're looking at the baseline figure, the judge said, well, you determine that using an objective test. So, what would a reasonable buyer and seller have agreed to be the most likely estimate of the relevant factor over the relevant period? And in this case, the judge said that the baseline figure was that the company would generate around £1 million of EBITDA in 2018. But the actual EBITDA for that period was then assessed as being 0.3 million. So, was the difference between the baseline of a million and the actual figure of zero point 0.3, was that material? So here, this was one of those cases where there was no express guidance in the agreement as to what the parties thought was material. So the judge had to look at this, and the judge said, well, it's an ordinary English word, and its application to a set of primary facts is of itself a question of fact. So the question of materiality had to be determined by reference to an objective test. So what the court said you would do was think about, well, would a reasonable person entering into the transaction with the aims and objectives of the buyer have sought to withdraw from or renegotiate the transaction had they known of the particular change? And in this case, the judge said, well, actually, yes, a reasonable buyer would have attempted to renegotiate the sale price had it known the true state of the company's affairs. So the difference between the forecast EBITDA and the actual figure was material, and the sellers were in breach of that MAC warranty. It's quite an interesting decision because actually, perhaps surprisingly, given how often MAC provisions are included in commercial agreements, there's actually very little English case law on them and what is meant in particular by the word material in the context of a MAC provision. And so in this case, actually, the judge in the English case made reference to case law on the subject from Delaware in the US, and that confirmed that what was relevant was the effect when viewed from the long term perspective of a reasonable buyer. So, just a kind of short term hiccup in earnings wasn't going to be sufficient. That wasn't going to be material. You had to take a more long term view. Um, Interestingly, the judge also rejected arguments that the test of materiality should be linked to whether the relevant matter was material for accounting purposes. So, in relation to that, a measure of around 5% of profit before tax is often used as a measure of materiality. That's what accountants and for accountant financial purposes might be considered material. But here the judge said, well, no, that's not relevant. The two tests are separate and they perform entirely separate functions, and so there's no need to read across between them. So an interesting case, but perhaps maybe the key lesson is that you might be better off setting out in your contract exactly what you think is going to be material in the context of the specific deal. That would then allow you, the parties to the contract, to take into account your own subjective opinions on actually what you think is material. And it would also make you think about it and focus on that particular issue, which is probably going to be better than just leaving it to an objective assessment by the court if there's a subsequent dispute where actually what you personally thought might be material won't necessarily be taken into account because the court's just going to approach it much more objectively. So interesting decision there, a bit of guidance on that word material. And then the next case that I thought we'd have a look at actually also looks at some kind of common language, this time about what are serious and persistent breaches of an agreement. This one was in the context of an LLP, a limited liability partnership, expelling a member. And the court ended up having to take sort of quite a commercial approach to interpreting the expulsion provision in the LLP agreement, basically in order to avoid a member of the LLP being required to consent to their own expulsion, which obviously was never going to happen. Turkey's not voting for Christmas. So this case then involved, like I say, a limited liability partnership, an LLP, and that LLP had been set up as a vehicle for a business venture between two individuals. So, on the one hand, we've got Mr. Mitchell, who was a software developer, and he'd written the source code for a piece of software which helped with options trading. And then we've got Mr. Sheridan. So, Mr. Sheridan was a former options trader who now provided training and mentoring services to people that were interested in options trading. So these two gentlemen set up the LLP in order to exploit that software that Mr. Mitchell had written. And the two members of the LLP were Mr. Sheridan and then a company called THJ Systems Limited, which was basically the corporate vehicle of Mr. Mitchell. So it's as if the two individuals are the two parties in the LLP, but one of them is a member via a corporate vehicle, THJ. So the parties entered into an LLP agreement, and that contained various different provisions dealing with their obligations in relation to the LLP and how that LLP was going to take decisions. So, in particular, Mr. Sheridan agreed that he would take certain steps to advertise the software that Mr. Mitchell had written and would ensure that all materials relating to the software contained appropriate copyright marks. Then THJ, so remember the corporate member of Mr. Mitchell, THJ is going to carry out the day to day running of the LLP and take all relevant day to day decisions. Certain matters, sort of the more serious stuff, not the day to day stuff, but certain matters were then expressly reserved to be for the unanimous decision of the members. So that's all the members of the LLP. But importantly, that didn't include the expulsion of a member. And then there's another provision that says the LLP could, by notice, expel a member for any serious or persistent breach of the agreement. So we've got day-to-day decisions being taken by THJ. We've got certain important stuff, big stuff, requiring unanimity of the members. And then we've got this provision that says just the LLP can expel a member. So, as you might imagine, otherwise we wouldn't be talking about it, the relationship between Mr. Mitchell and Mr. Sheridan gradually deteriorated. Mr. Mitchell accused Mr. Sheridan of breaching the advertising and copyright obligations set out in the LLP agreement. And then in December 2015, Mr. Sheridan received what was called a notice of expulsion that had been signed by Mr. Mitchell as a director of THJ, and it said that THJ had signed for and on behalf of the LLP. So that notice obviously purported to expel Mr. Sheridan as a member of the LLP on the grounds that he'd committed serious and persistent breaches of the LLP agreement. So remember, we've got that clause that says the LLP could, by notice, expel a member for serious or persistent breaches. So THJ has signed a notice of expulsion on behalf of the LLP, but THJ is only one of the two members of the LLP. So Mr. Sheridan disputed the validity of the notice. And in order to try and resolve things, THJ and the LLP applied to court for a declaration that Mr. Sheridan had, in fact, been validly expelled from the LLP. So when it came before the court, the first thing that the court had to decide was whether Mr. Sheridan had committed serious and persistent breaches of the LLP agreement. Remember, that's the basis on which a member can then be expelled. So the first thing is, well, have there actually been serious and persistent breaches? So when looking at that, the judge said, firstly, well, a serious breach is one that's material, linking back to our definition of material in the previous case. So a serious breach is going to be a material one, which is more than trivial, but less than a repudiatory breach. So a repudiatory breach is a really serious one that entitles the party to basically treat the agreement as being terminated. So it's somewhere between that serious repudiatory breach, but not trivial. So a serious breach had to have a serious effect on the benefit that the innocent party would otherwise derive from the performance of the contract in accordance with its terms. And when a court was asked to decide whether or not a breach was in fact serious, then it had to look at all the relevant surrounding circumstances. So that would be things like the nature of the particular contract, the nature of the contractual term itself that had been breached, the nature of that breach, and then the consequences or potential consequences of that breach. So that's what the court said was a serious breach. Then it said, well, in relation to a persistent breach, then as well as the relevant breaches being repeated, there also has to be some degree of gravity to them. So again, non-trivial. And the repeated breaches together have to add up to something which is serious in all those relevant circumstances that I just set out. So when applying those principles about what is a serious breach, what is a persistent breach to the specific actions of Mr. Sheridan in this case, the judge said, well, actually, he is, yes, in breach of the obligations in the LLP agreement that required him to advertise the software in the presentations that he was giving as part of his training. And the judge said, yes, those actions amounted to serious and persistent breaches of the agreement. So they weren't, yes, he'd breached it, but they'd gone further and they were indeed serious and persistent breaches. So because the judge had said that we did have those serious and persistent breaches, that meant that the LLP's ability to expel Mr. Sheridan had been triggered. So the court then had to go on and think about the validity of that expulsion notice. So if you remember, the LLP agreement said that the power to expel a member was vested in the LLP. So it was the LLP that had to exercise that right, had to sign, had to give the notice of expulsion. So remember, the LLP agreement said that day-to-day decisions relating to the LLP could be taken just by THJ. But the judge said, well, actually, expulsion of a member isn't just a day-to-day decision. You know, it's a more serious thing than that. So it isn't a decision that could have been taken by THJ under the provisions of the agreement relating to day-to-day decisions. But also remember, the LLP agreement listed out certain specific matters which it said required the unanimity of the members. But again, expulsion of a member wasn't listed there. So it wasn't something that required unanimity of the members. So what did it require? Well, the judge said, well, that means basically it's something that has to be decided on by a majority of the LLP members. But the problem with that is, if you remember here, we've only got a 2-member LLP. So that would ordinarily mean that both members of the LLP would have to agree. But in this case, the judge said, well, if we're going to construe the clause here as requiring Mr. Sheridan to vote for his own expulsion, that's going to be absurd and would render the clause ineffective. So the judge said that the clause that gave the LLP the ability to expel a member should be read as saying the LLP acting for this purpose by the members other than the member concerned. So the judge came up with quite a neat way of getting round that problem of in a two-member LLP where something requires the majority of the members effectively asking a member of the LLP to vote against themselves. So it's a neat solution. It's a commercial approach. It wasn't the approach, unsurprisingly, advocated by Mr. Sheridan. He said that the clause should be interpreted strictly, requiring a meeting to be held at which all the members had to participate in good faith and reach a decision. But realistically, in a two-member LLP, that kind of approach is unlikely to have ever produced a satisfactory result. Um, Lots of commercial contracts contain termination rights or provisions which are linked to serious and or persistent breaches of the contract terms. So again, it's quite useful to have some guidance there about actually what those terms mean and how they're going to apply in practice. Okay, that's it for cases this month. But then I thought finally we'd just have a quick look at the policy paper that the government has issued called Smarter Regulation to Grow the Economy. And basically, this is setting out its plans to improve regulation across the UK by reducing burdens, reducing the cost of living, and driving economic growth. So it's effectively the government setting the scene for how it wants things to change post Brexit. But at the same time that that policy paper was released, the government also had to backtrack, take a different approach on its proposals to repeal all retained EU law at the end of this year. So you might have heard of a bill that's currently working its way through Parliament that was nicknamed the Great Repeal Bill. And that act contained, or bill, sorry, contained a controversial sunset provision. So what that did was it said that all retained EU law that was either in domestic UK secondary legislation or that was direct EU legislation that applied in the UK, all of that retained EU law had to be repealed automatically on the 31st of December 2023, end of this year. So obviously that was intended as a post-Brexit deregulation measure aimed at removing and reforming what was seen as burdensome EU laws. Um, but a lot of concerns have been expressed, including by the Law Society, that actually that's going to have what the Law Society referred to as a devastating impact on legal certainty and business confidence. Because what was going to happen was just automatically everything would be repealed, but there wasn't really sort of a list or an understanding of exactly what that was going to be. Um, it was estimated that that would mean more than 4,000 pieces of legislation would fall away under the sunset provision. But as I say, there's been a change of approach here. So now there was a written statement from the Secretary of State for Business and Trade, which confirmed that actually, instead of just having this sunset provision, which automatically repealed everything, we're going to have a list of specific pieces of legislation which will be revoked at the end of the year. So that's going to be around 600 pieces of legislation. That's added to, by the way, over 1,000 laws which have already been revoked since we left the EU. And then there's another sort of 500-ish that are going to be repealed when a couple of bills, the Financial Services and Markets Bill and also the Procurement Bill, become law later this year. So instead of that sort of cliff edge of everything falling away, but nobody being quite sure what everything was, we're moving to identifying specific pieces of legislation. And I'm sure that no doubt others will be added over time. So um, that's the written statement in relation to that sunset provision. The other thing that I mentioned was this policy paper. So the policy paper that the government issued says that when businesses are tied up with red tape, then their ability to innovate is limited and prospects for national growth are hampered. So the government is looking to reform what it calls its better regulation framework, essentially to reduce those kind of administrative regulatory burdens, so that non-regulatory approaches are considered and any new regulatory proposals receive much earlier and more rigorous scrutiny before they're imposed on businesses. So the paper highlights that the government's committed to reforming existing regulations, and in the first instance, it sets out some proposed changes to employment law that it believes are going to cut red tape for businesses, but whilst also striking a balance and safeguarding the rights of workers. So there are three specific measures in the employment law field that have been proposed. So the first one relates to non-compete clauses. So the government is proposing limiting the length of non-compete clauses just in employment contracts to 3 months. And it believes that this is going to help workers more easily switch jobs, apply their skills elsewhere, either by joining a competitor or by setting up a rival business. So the government does recognise, it does say in the policy paper, look, we recognise that non-compete clauses play an important role in protecting businesses, but we believe that this proposed change will help businesses to compete and innovate by recruiting new staff. But just to be clear, we're just talking about non-competition clauses, so not non-solicitation of employees, non-solicitation of customers. We're just talking about non-competition clauses, and we're only talking about them in the context of employment agreements. So we also see these types of restrictions in lots of other commercial agreements. So, for example, in share sale agreements, um, franchising agreements, investment agreements, all of those kind of things. Those contracts aren't going to be affected. We're just looking at employment contracts, and within the employment contracts, we're just looking at non-competition clauses. So that's the first one, limit non-competition clauses to 3 months. The second one relates to what's known as 2P, the Transfer of Undertakings Protection of Employment Regulations, which we all abbreviate to 2P. So basically, where a business transfers to a new owner, under those regulations, the business has to elect employee representatives with whom it can consult about that proposed transfer of employment. So the government's going to remove that requirement for businesses with less than 50 employees or transfers affecting less than 10 employees. So if you fall into one of those categories, then your business will just be able to consult directly with the affected employees. You won't have to go through the process of actually electing employee representatives. And then the final one is that the government intends to remove the requirement, which has been derived from case law relating to the working time regulations, for businesses to keep working hour records for almost all of their workforce. And then linked to that, there's going to be some proposed reforms reducing the burden and complexity of how you calculate holiday pay. So I think broadly looking at those proposed changes, I think businesses are going to welcome the reduced scope of the 2P regulations. So those kind of much smaller transfers aren't overly affected in an overly burdensome way. I think the change to the working time requirements are probably going to be welcomed. Again, reducing those record keeping requirements. I think the changes to non-compete clauses are maybe more likely to be seen as a bit of a double-edged sword. So on the one hand, you're going to have greater freedom to recruit, um, but that's going to be coupled with an increased risk of workers using their knowledge to erode business and goodwill of their former employee when they move on elsewhere. So, as I say, I think because of the scope of that proposed um, restriction, what businesses need to do is rely more on the non-solicitation and the non-dealing restrictions, which are going to be outside the scope of the proposed reforms. So that's it. A look at a couple of historic cases and a look at some things coming up in the future. Hope you found that interesting. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.